Okay, so we just started recording, and again, my name is Tara Van Ho. I'm one of the two co-directors of the Essex Business and Human Rights Project, along with my colleague Miriam. And it is our pleasure to be hosting this along with the European Center for Constitutional and Human Rights, or ECCHR. This is the latest of a series of ongoing collaborations that we've had with ECCHR, which is one of our favorite NGOs in the world. And we're lucky because they're German, and so they could actually explain to us what this event is. And I'm going to tell you how I pitched it to Miriam, which was, could we have an event where we get all of my favorite people from business and human rights in Germany together in a room so they can tell me what's going on with this law, how I should think about it, and what I need to learn before I teach it next year. And that's what today's going to be. We'll be using various English translations or shorthands for the law, and that's because not only are we doing this in English, but in Illinois, we don't speak German. So I'm also going to right now issue a blanket apology to our German-speaking friends, colleagues, guests, speakers, Anil's German high school teacher and my great-grandma Frischkorn, for the fact that we will not say a single German word correctly today. It's possible we'll say like 3 words correctly, but I'm going to guess that we're not going above 3. And so apologies in advance for mispronunciations of names, locations. Hopefully we don't have to use any legal words, but if we do, we will also mispronounce those. So I deeply, deeply apologize for that. And I appreciate the patience of all of our speakers who already know that we will be mispronouncing their names. This is a really timely event and we're very excited about it. We originally thought we would be doing this the day before the law passed, but it turns out that we're not. The parliament was supposed to vote on the law tomorrow. They have postponed it. There are various rumors about why they have postponed it that we will not be getting into. I mean, the speakers are allowed to if they choose to, but we're not going to get into it from our side. But it does mean that we're hoping that there is some space for enhancing the law and seeing how it can be made more robust, in my opinion, more robust. Maybe some of you would disagree. And so sorry, one of the co-hosts muted me. So hopefully we're going to get a chance today to talk a little bit about where the law's shortcomings are now and what we can hope for in the future. We are excited that within this meeting, there are various stakeholders. We have businesses, NGOs, companies, think tanks, law firms, and universities from a variety of different countries. So we're hoping for a very robust conversation, a deep conversation about the law and its limitations. Please be respectful, obviously. And as you just saw, we do have the ability to mute you if we need to. Hopefully that won't happen. I'm going to turn it over to Miriam to introduce ECCHR and then to Anil to introduce EBHR, and then I will come back and explain the order of events for today. So Miriam.
Yeah, thank you, Tara. Thank you so much for the opportunity and the great idea you've had of hosting this event. At ECCHR, we are a legal organization that uses law to advance human rights. And in particular, in the business human rights program, we are looking into cases where we can bring transnational corporations based in Europe to account for human rights violations in abroad. And obviously, I think, as I've been building up this program, I know that a lot of my colleagues who are doing other work on, for example, international crimes have always been like saying, yeah, Miriam is doing the one that does the hopeless cases, no? Because obviously there's not even a proper procedure that I could go into. You won't find a book about transnational corporate accountability. Now, by now you do find books, but you won't find a book that explains to you which court to use, which arguments to use. There is no law in Germany at the moment that would regulate transporter human rights violations in which companies are involved in. And so it is an exciting time that we are quite close to this law, even though, you know, we will talk about all the weaknesses of what we have now. Yeah, just to think about that, most of the people that are campaigning for this law now, we've started that debate probably 11 years ago. So it's and it's quite and a number of those people are actually also now today here with us, also on the panel. So, you know, that is yeah, so I'm very much looking forward. I also wanted to highlight that what I have always believed in, and I think this also shows this process, how important academia is also in those processes. I know how we've had debates about, you know, when is the right momentum for a campaign for such a law. And at the time, 2014-15, I really felt like, well, if we don't even have an academic debate, if there's no law professor that has ever even thought about the possibility of such a law, and for example, how to create civil liability, how many chances is any idea of a law going to have, right? So you do need academia, and you do need, you know, to build up a thinking and also the expertise to even make such a law in any way realistic, also even technically on, you know, how would you regulate certain. So, and we will have a lot of detailed, and I'm very glad, a lot of detailed, because of also very important discussions on how this law is currently designed and what are the weaknesses, and probably, but also what are the strengths. And so I'm very, very much looking forward to this event today. Thank you.
Thanks, Miriam. And thanks for that shout out to the academic world. If you are interested and you are an academic, I will put a link to the Global Business and Human Rights Scholars Association and to the Teach Business and Human Rights Forum in the chat so that you can join us and trying to make the academic world also practice focused and friendly. Speaking of which, Dr. Saage-Maas Vestardis will introduce the ECCHR.
Thank you, Tara, and thanks to all our panelists and guests today joining us. I will just introduce quickly the Essex Business and Human Rights Project. The project is an academic unit which is housed within the Human Rights Center at Essex University, and its members consist of academics from various disciplines with expertise on business and human rights. Many of you may know Professor Sheldon Leader. He's the one who's founded this, this project more than a decade ago. And it's currently led by Professor Leader, Tara Van Ho, and myself. And we always aim for our research to inform policy and case law in this area. Yes, we produce research for the sake of research, but we always aim to also consider how we can influence the policy debates in this area, how we can support litigation, civil society, and we regularly work with civil society organizations to support their work in the area of business and human rights. We also have an education mission, and this covers both providing trainings to external organizations, but also involving our own students in the work that we're doing, both research and both collaborations with external partners. We have in the past worked with ECCHR on several different collaborations, but one of the most well-known ones is our work together with them on the KIC case. And that was also quite an important learning process for us as academics to work closely with an organization that's litigating, bringing accountability, and how academically we can contribute to that debate. It was a great learning experience for us. And thanks. I will hand it over back to Tara.
Thanks. While we're talking about our students, we do want to give a shout out to Jana Hos, who is one of our current LLM students and who organized today on our behalf. She is on the market for a job, and she just showed up on our screen. I think she's still on the market for a job, right, Jana? So if you need somebody that I endorse, there you go. You can find her in the participants list and give her a job offer. With that, oh, nope, I still have to tell you how we're going to do today. So today is going to be a little bit different. We're going to start with a panel that's going to explain how the law is supposed to work, what the law is supposedly going to do, keeping in mind again that the vote has been postponed. So I don't know if there are any realistic hopes for changes, but we will find that out today. That's going to take about 30 minutes for the speakers to sort of set out the law, its scope, its remit, and its limitations, as well as its enforcement capacity. After that, we're going to move straight into the second panel, which we are going to go off the record for. We're going to stop recording at that point, and it will be Chatham House. For those of you who don't know, that means you can cite to the general discussion, but you cannot cite to or quote an individual on the panel. We're going to do that because we want to have a really blunt exchange about the realistic hopes for this law and the realistic expectations for its success or real implementation and enforcement. After that, we're going to take a 10-minute stretch break, come back, and the rest of the time will be dedicated to Q&A with you. If you have questions throughout and you're dying to ask them and you're afraid you'll forget them, just leave them in the chat. We will come back to them during the Q&A period. At this point, I'm going to turn it back over to Anil to moderate the first panel. I'm going to turn my video off so I can make ugly faces while I take notes. And Anil.
Thanks, Tara. So without further ado, I'm going to kickstart the first panel. It's quite promising to see that Germany is introducing a law on corporate due diligence to avoid human rights violations in supply chains. This is the formal title I got from Google Translate for the law. Although I find it quite puzzling that there is just this exclusive reference to supply chains, which to me seems a little misleading, but I'll let our speakers talk about that. But commentators have criticized the law for not doing enough to bring about corporate accountability. So we're going to have three speakers, three panelists explaining us the details of the law. We're going to first hear from Robert Grabosch, who's a lawyer specializing in commercial and corporate law and in the field of corporate responsibility at Schweizer Legal. Before joining Schweizer Legal, Robert had founded a German-Dutch law firm and led it as a partner for 4 years. During his master's studies in South Africa, Robert specialized in international business law, private international law, as well as business and human rights. Since then, he has published regularly on the topic of corporate social responsibility and has been invited several times as an expert in political committees. So Robert, the floor is yours. Looking forward to hearing your thoughts.
Well, thank you so much, Anil, and thank you, Tara and Miriam, for inviting me. I'm happy to present to you in about 10 minutes the personal scope and subject matter scope and the reach of diligence into the supply chain. So this bill that is currently considered by Parliament is, let me share my screen, supposed to apply to can you see my PowerPoint? Great. It's supposed to apply as eventually as from 2024 to companies that have at least 1,000 employees. It will start to apply even a year early in 2023 for those that have 3,000 workers employed. And this regards companies that have their statutory seat or their administrative seat or their principal place of business in Germany. So it even applies to some foreign companies that are registered abroad, but that have an administrative seat or their principal place of business within Germany. And one of the issues that the Parliament is concerned with at the moment is that it doesn't seem to apply to enough foreign companies, because there are many other foreign companies, of course, that sell goods regularly to German buyers, that even have warehouses or stores in Germany. And they are so closely linked to the German market that this statute should also apply. And in fact, the Parliament is currently considering extending the personal scope so that certain further foreign companies will also be included. And when it comes to calculating the number of employees, the subsidiaries employees also count. And at the moment, it looks like all employees count, no matter whether they are employed in Germany or abroad, but this may also still change. There are certain details that are currently being discussed, such as whether part-time workers count or apprentices and so on. But in principle, this act will eventually apply to companies with 1,000 employees across all business sectors, and no matter how much their turnover is. So then which human rights or environmental aspects does this law cover? Well, we learned from the French loi de vigilance that a law that has an administrative enforcement mechanism must not be too vague. It has to be very specific, because otherwise the constitutional courts will strike out any penalties. So the German legislator really took a close look at how to phrase the rights that should be protected. Merely saying human rights is not enough. Companies have always been complaining that human rights have a very vague meaning. Many people have doubted that they exist at all. Some have said that they are mere aspirations, declarations of intent, and that they are too vague to be applied in law anyways, and that they bind only states. So there have been many objections to human rights. And to some extent, all of these concerns are true, but also they have largely been exaggerated by some actors in the business community, so as to be excuses to not live up to responsibility. So the German legislator really made an effort in defining human rights in terms of some very specific risks, definitions of risks that company can easily implement into their risk management system, so that they don't have an excuse anymore and cannot say, we don't know what human rights are. And these are 11 plus 1 plus 2 definitions of risks. The human rights risks are those that whenever there is a significant probability based on actual circumstances of a violation of 12 prohibitions or rights. And what you see on this slide is abbreviated very much. This is actually in the law 3 pages. So these definitions are much more detailed than they look on the slide, but they cover child labor, forced labor, modern forms of slavery, safety at work, labor unions, equal treatment at work, including equal pay, living wage, which can be above minimum wage, pollution of land and water and air, if it affects humans, the possession of land, excessive force by security services, especially when applied to labor unions. These are specific risk definitions, and then there's a catch-all risk definition, any act or omission beyond those 11 risks, which has the potential to directly violate human rights in particularly severe manners, and the wrongfulness of which is obvious on sensible evaluation of all circumstances. So the threshold is very high. And all these risks refer to the International Bill of Human Rights and to the 8 ILO core labor conventions. And then there are also 2 environmental risks, namely the use of mercury, which is prohibited since 2013 by the Minamata Convention, and the risk of persistent organic pollutants, which relates to the 2001 POPs Convention. So you see very detailed definitions of risks, but also a catch-all phrase that allows us to apply this law extensively to further risks that may become important. Then there's a big issue with how far diligence should reach into the supply chain. And first of all, diligence has to be applied by the company in its own business area. And of course, that includes its business sites, no matter whether they are in Germany or abroad, as long as they are run by the company. And there's an issue as to subsidiaries. As Anil just mentioned, it's not very clear whether subsidiaries can be in a company's own business area. Sometimes a parent company controls and manages a subsidiary so tightly that you would say, yes, this is the parent company's own business area. But the law does not make that clear. It doesn't mention subsidiaries. So I asked the parliament on Monday to improve the wording of the statute and include a clause that regards subsidiaries, and hopefully this will happen to clarify this issue. Then diligence must also be applied to all direct suppliers, no matter how strong the contractual relationship is. As long as there's a contract to a supplier directly, diligence must be applied to that supplier. But then the duty to perform a risk analysis suddenly stops. And we all know that the most severe human rights risks occur at the beginning of the supply chain. So it almost makes no sense that you would not have to apply diligence beyond tier 1. But then there are 2 additional ad hoc duties of diligence, namely whenever a company obtains substantiated knowledge of a possible infringement, then a risk analysis and mitigation measures must be applied. And also whenever a company introduces new products, new projects, or accesses new business fields, then also a company has to take into account the human rights and environmental risks that are apparent. And I really believe that over time, because of these ad hoc risk due diligence duties, the act will become stronger and the supply chains will get cleaner over time. And now it looks like this act does not quite cover the scope of the UN guiding principles, but I think it will over time. And then as to the measures of diligence, I just want to keep this brief. Basically, everything you see from the United Nations guiding principles, I think, is covered in this act. Companies have to perform a risk analysis, a policy statement must be made, preventive measures must be taken out, and remedial actions, complaint procedure, and reporting. All these measures of diligence are subject to the criterion of appropriateness, which is also specified by 4 explicit criteria. And the Act also makes it clear that withdrawal from a business relationship is only a last resort, only when in very severe circumstances, when 4 factors are met, a company has to withdraw from a business relationship. So this is it for a broad overview. And I think if this act passes as it is now in the current state, in the draft by the government, it would certainly be one of the strongest acts, one of the strongest due diligence act that we have so far in the world.
Thank you, Robert, and thanks for finishing well on time. This was very informative. It was a great introduction to the law. So now we're going to turn to Anna Beckers. Anna Beckers completed the German bar exam in 2010 before obtaining her PhD from Maastricht University in 2014 with a thesis on the legal enforcement of corporate social responsibility codes. Since January 2015, she's an assistant professor of private law and legal methodology at Maastricht University, where her research is focused on international commercial law, as well as European and comparative private law and corporate law and governance. Regarding legal theory and methodology, Anna is interested in normative approaches to legal research, particularly social theory and legal sociology. She regularly publishes articles on corporate social responsibility and value chain issues. And Anna will talk to us today about the content of the duty in the law, and I'm leaving the floor to Anna. Thanks.
Yes, thank you very much. I will also share my screen. Here we go. And yeah, so I've been asked to talk a bit about the content of the duties. By this, there might be a bit of overlap with Robert, but not so much in terms of, so I will keep that part short, that informative part short, but I also have a couple of points for discussion to be made that we can later on talk about in the chat, also outlining a bit sort of what are the problematic or critical aspects in the law. So I'm talking also quickly about rights, risk and rights. And as I said, I'll keep that short. And substantive obligations. So what is the definition of due diligence? What type of obligation? How far does it reach? But building up on what Robert has said. So as Robert rightly said, the human rights risks are oriented on the ILO labor conventions and International Bill of Human Rights. And this is, I find very interesting, there is a catch-all category for what is called serious and obvious infringements of rights. So it's very specific in that respect. And it covers environmental risk. But here we are in the first aspect, I would say, where the law is very specific, and it needs to be specific, of course, but where it cuts off a couple of the policy discourses and the other legislative development that have been coming in on due diligence, in particular on merging due diligence also with human rights due diligence with environmental due diligence. So when you look into environmental risks, as Robert said, there's two specific conventions that are mentioned that are related to particularly dangerous products or dangerous materials, and mercury and persistent organic pollutants. And other than that, you find environmental aspects mainly considered as part of human rights. So when we talk about pollution of soil, that's also partly included, but then not as an environmental risk, but as part of human rights. Not in that sense a very general environmental due diligence. It also qualifies as a risk, I've used a bit of a broad translation, and defines as a risk a situation in which factual circumstances permit inference with sufficient certainty that a right is likely to be infringed. So it's very much using this idea of risk that companies have to take where there's an immediate, where there is a possible immediate threat for rights violations. And that brings me a bit to the points of discussions. As Robert rightly said, it's very specific, the law, in terms of referencing international frameworks. And I think that is a major step. It's essentially company law legislation that is passed now that obliges businesses to not directly to respect human rights. It's not a result-oriented obligation, but it's making human rights applicable to businesses. And when I look into let's say in my past, when I have also been starting working on this issue, at that time very much also framed still in the field of corporate social responsibility, and that among company lawyers was a very narrow topic where a lot of people were discussing, is this really law? And it has changed with, not already there, with the non-financial reporting directive, where now everyone in company law is talking about CSR, about social and environmental aspects. So you can see how regulatory efforts and regulatory initiatives change also the way in which certain topics are becoming relevant for business. And I think there we have a major step with the due diligence law, and we have an enumeration of international frameworks. So also to say no, so it's not it. So there's still a lot of ambiguity in the law, but it is specific enough in saying, okay, it's not what companies make, how companies make sense of human rights. It's about a particular set of international frameworks which specify rights. But as I said, one of the points of critique, and I know. Of course, there has been also a lot of discussion on that, is that lack of a broad integration of environmental risk. And I find this quite surprising, because if we look at the EU level, we have a number of developments. The EU Parliament's proposal includes environmental aspects in a much broader way. But we also have the Sustainable Corporate Governance Agenda, which will also likely become more regulatory and contain legislative developments where also due diligence is considered a core part. And also this is one of the points for discussion also, that of course the definition of how to define a risk is very, it's not ex post in the sense of it has to already have occurred, but it's very much looking at concrete risk of a violation that is likely to occur, and not ex ante on general prevention of risks. As I said, so the substantive obligation, if you look into sort of what companies have to do in relation to eliminating these risks, there's a detailed outlining of the required step, and as Robert said, it's very strongly oriented on the UN guiding principles. So we have risk management, risk analysis, policy commitment, preventive measures, remedial action, complaints procedure, documentation, reporting. And this is several pages of the law. So there's a lot to say about this, much more than I can do. But I would also say, I mean, it's in that sense generally very specific in terms of the steps that companies have to take. It's not a best result obligation that doesn't become sort of completely clear from the law. I mean, it's a bit in the way in which it is framed, but it becomes very clear from the reasons. Of course, this does not mean that it's a best effort to conduct due diligence. It just means it's a best effort in terms of the rights protection. Where are we going? And as I said, the law is very specific, but it uses frequently concepts such as appropriate, so appropriate risk management, and a company, when it encounters or when it identifies risks, has to act without further delay. Suggesting, of course, that while this is specific, these will be concepts that will be become relevant in should the act be implemented in the further, let's say, specification in the practice, in the administrative practice, administrative enforcement, but also once courts are to be reviewing due diligence concepts, risk management strategies. So also points for discussion, as I said, I mean, it's a quite detailed regulation of the steps that companies have to take, and also thinking about the devoir de vigilance now as a first step that had been taken, which is much broader on this than what we would have here. So it's outlining, the law would be outlining very specific what companies have to do. But of course, I mean, this is not necessarily a negative point, but it is one that needs to be considered. I mean, once you have our lawyers' business is that we have that we deal with open-ended concepts, but of course, we need to think about how, who's to be deciding, for instance, what is an appropriate risk management, and what does without further delay mean. And here, I mean, the law isn't yet very clear. You have a provision that states that there needs to be guidelines provided by the administrative agency, about which Miriam, I'm sure we'll talk about extensively. So sector specific, but also general guidelines. And you also have in the reasons some reference to international standards, the sectoral guidance by the OECD as a point of reference. But I think this is something where we will inevitably have a lot of unclarity in the beginning, which will need to be specified in the course of the act being then implemented in practice. And here I think it's becoming important. I'm not going to talk about the enforcement because that's Miriam's topic. But there will be a lot of discussion, sort of who is doing that. I mean, in the moment that the act comes into force, you will have, first of all, companies who are deciding what is an appropriate risk management and risk analysis, and how to respond to these risks. And then we will have at a later stage the discussion and courts coming up, and there it depends very much also on how the courts will be involved. And as I said, in the final the type of obligation, so it's very clear. It's presented as a best efforts obligation, and I mean best efforts obligation in the sense that it's not a duty to and also when a harm occurs in the supply chain, that automatically means a company has breached its duty to conduct due diligence. It's really an let's say a process-based obligation. And I would think that the most important aspect, and I think also a reservation on why this has been included, is that obviously this makes it a bit more difficult to link it to civil liability. As we know, there's not a specific clause in there that's on civil liability. You can just infer it from the act that there might be civil liability. But of course, a best efforts obligation is much more difficult to translate into a tort law duty of care. And also what I found puzzling, also given the discussions on an EU level on directors' duties and sustainable governance, is that, as far as I know, at least the Act doesn't really, so it's a company obligation, no? It doesn't refer to the directors. And finally, so now again, I'm leaving that because Robert has talked about this already, about that it contained that there's a broad definition of the value chain, own business and direct suppliers, and second tier when risk could have changed and when the company has obtained substantiated knowledge. But here, I mean, that's as I understand also in all the due diligence legislation and proposals that are discussed, one of the main points of discussion, that you have a, so how far do you go in the supply chain? What do the companies have to do? And here, I think, I mean, if I put it very sort of positively, I think also one of the major points that where this is a game changer is that this law is stating a responsibility of companies for contractual partners. So it's so what a long time, so not only companies, but also academics have always been saying sort of we need to distinguish between, let's say, buy or make, contract or organization. And this law says, no, you know, there are also situations in which you contract and you nonetheless have a responsibility of what your contractual partner is doing. And that not only if you quasi-integrate, but also if you contract, you need to overlook on what is happening with contractual partners. It also is interesting that it contains a definition of the global value chain. Yeah? So the global value chain is not a legal concept, but now we have a first idea that we're talking about a global production process. And that's what I'm going to end with, there's a limit in the coverage of the supply chain. And what I found quite puzzling is that I do understand that the distinction that you say, okay, you only have to look first tier because that is quite manageable. These are your direct partners, but you have to only go further if you have substantiated knowledge. But substantiated knowledge is quite high threshold, no? So in law and also in tort law, when we look into the case law there as well. You often have reasonable knowledge so you should have known this. So I'm wondering, this is at least I would say one of the weaknesses. But, and this is what I'm really going to end with, don't forget other legal areas. No, I mean, I can only now touch upon, so if you have effective due diligence mechanisms, they can also have an impact on contract law, no? And contractual duties, contractual remedies. And we have parallel developments also in terms of what I call market regulation on the EU level, that you have certain regulations of global value chains in terms of preventing unfair trading practices, which could work hand in hand with due diligence legislation and then also going further down the chain, let's say. And with that, I'm going to end my presentation.
Thank you, Anna. Thank you for that detailed discussion on the content of the obligations, substantive obligations, and points for reflection. Without further ado, I'm going to pass the floor to Miriam Saage-Maas. She's a lawyer and vice legal director of ECCHR, where she has built up the business and human rights program. She has worked on various cases against corporations, including civil proceedings against German retailers relating to the exploitation of workers in Bangladesh and Pakistan, and against companies trading in cotton picked by forced child labor in Uzbekistan. Miriam is also engaged in criminal proceedings against high-ranking officials, for example, in the European arms industry, for their involvement in the commission of international crimes. She regularly publishes articles on questions of corporate accountability for human rights violations in the global supply chain, and she consults internationally as an expert in corporate responsibility and human rights. She's a lecturer at the Freie University of Berlin, and she joined the Stiftung Forum Rechts Advisory Board in 2020. Miriam will talk to us about the enforcement mechanisms within the law. Miriam.
Thank you. I will also share my PowerPoint presentation, which you can see now. Yes. Okay. Yes. So I will speak about the enforcement mechanism in the German supply chain law as we know it now. It's very much restricted to public enforcement, and I will speak a little bit about the lack of civil enforcement, but it's a bit less because nothing is in the law if we want to know for now what's in the law. I think a starting point also to understand how the mechanism of this public enforcement works is to see that I think that the reporting and documentation obligations are quite clearly defined. Anna has mentioned that also before. So companies need to document all their efforts they undertake in order to fulfill their human rights due diligence obligations under this law. So that means it's not only that, and then in addition, they need to issue a report once a year, but that means they need to keep the documentation, I think, for at least 7 years in their companies. They need to store this. The law also outlines criteria on sort of what this reporting needs to cover. So yeah, while I'm not an expert on due diligence reporting, but I think there can be some hope that those reports need to be, at least they can't just be, 0.2 of or 2.0 version of the CSR report that companies usually issue. So what you have is that's in Article 14. There is an administrative body is sort of giving the obligation to control compliance with the law, and and also with the obligation to investigate into potential violations of the rights being protected by the law. So that means it's not only that they need to have a look if do companies report and do they do their human rights risk assessment, but also they have the obligation to investigate if they think that a rights violation occurred. Obviously, in that decision whether or not to start an investigation, the administrative body has discretion. It is only then obliged to act. But then it's also legally obliged to act if a person that has suffered a rights violation or can sort of claim that it's an immediate danger of suffering a rights violation is putting forward a formal request to the government agency, and then it will need to act. The Ministry of Labor will regulate then the further procedure of this agency. The government agency is empowered to take appropriate measures to investigate and remediate the human rights violations, which means they can subpoena company personnel. They can order the company to publish a plan within 3 months on how they are going to, in which it details on how they're going to end the rights violation. They can order concrete actions of company needs to do in order to fulfill its obligations under the law. It can enter company premises and seize relevant company documentation, and it can access internal information of the company also in relation to its direct and indirect suppliers. That the authority is given to the BAFA, which is the Federal Agency for Export Control and Economy. And this institution is in Germany has a problematic track record because it's also it is also competent for regulating arms exports or for granting licenses for arms export. And we've had just in the last couple of years several cases where it's clearly shown that they are extremely closely aligned to business interests and to business. So it's not necessary that this is the best authority to look after that. So plus this authority is also subordinated to the Ministry of Economics. The interesting thing is, and I think that's the political the political solution, or within the government, is that so the ministry is subordinated to the Ministry of Economics, but it's the Ministry of Labor that is competent for further regulations of how this agency is going to act. There are foreseen sanctions for non-compliance with the human rights due diligence obligations of this law. So they can go, so they differ between 100,000 and 800,000 euros, and they can go up to 2% of the annual turnover in cases of no or insufficient remediation in very special cases. It is also clear that this is, I think from civil society perspective, we have been asking for higher fines and so that, their companies would take that more seriously. At the same time, with this option of that 2% of the annual turnover is being seized, I have heard several of my colleagues say that that are also advising large businesses, they do think this makes this law relevant, relevant in the sense of directors' duties under, well, Article 93 of the Aktiengesetz. I don't know how to translate that into English, but that it does create a director's duty because it will have an impact. It can potentially have an impact. The fine can have an impact on the company's shareholders' interests. There's also the option for being excluded from public procurement. That is only in cases of violations that have led to a fine of 175,000 euros. In other areas of law, companies get excluded from public procurement for much lesser fines. So that's something that can be criticized. Also, there's no exclusion, for example, from foreign trade support. So I think what we can say is, I do think that this administrative route of enforcement, and also especially the possibility for affected persons to initiate investigations. And what I then forgot to say is, once the Article 14 creates a subjective right of victims, which means they can also go to court. So they can take the government agency to court and say, this government agency has not been effectively protecting my right because it has not effectively investigated and fined and ensured remediation. So, and I think there are a number of unclarities in that, but I think still this is why, at least in other debates that I've had at the EU level, it's not just public enforcement, as you can see probably in the, I don't know, timber regulation or so, right? Because it's individual, like affected persons can go and claim. Obviously, you always need to claim that your rights have been violated or are in immediate danger of being violated, and that means it's not fulfilling the idea of the UN guiding principles, which are much more sort of preventative and in the area of risks. So I would say this becomes relevant always for people whose rights have already been violated and that already suffered violation. Obviously, again, the effectiveness of this procedure will all depend on the government's agencies' capacities and expertise to control compliance, on the capacities and expertise to handle complaints of affected persons, and obviously this also depends on political will. So we will need to see. Yeah, I spoke. So you have subjective rights; they can be taken to court. So yeah, I think we've had that also before. I do think it creates human rights obligation that for companies that have not existed before, and I think this law is a clear shift from mere voluntary CSR obligations to legal obligations. We do have a legal procedure, although it's an administrative law and therefore more indirect. I would say in the area of civil law, we stay very much at the status quo, which is you would go under the Rome II regulation. You need to then have the tort law if you want to go for civil compensation. You have to have a look at the tort law in the country where the harm has occurred, and with all the problem that creates. And then you will need to argue that there was an obligation. Usually, you would have to argue with something around duty of care or vicarious liability. And that then you need to know if that exists in Nigerian law, that exists in Indian law, Pakistani law, or Latin, any Latin American state. And therefore, the legislator did not take the chance of actually creating more of legal clarity. They could have said, we're creating a civil cause of action, and therefore we completely clarify what the obligations are, what the obligations are if they want to avoid civility. And so I would say to some extent, it is disappointing. But then from a practitioner's perspective, I sometimes also think, especially with the recent developments in UK law, and given that the British Empire used to be very big, and so there are a lot of countries that are common law jurisdiction where you could always argue, well, English decisions on parent liability and English jurisprudence on parent liability is relevant for for interpreting Nigerian law, for example, which is, for example, also being done in Dutch courts now. So, and with that really extensive liability scope, I'm not sure that companies are really much better off with this regulation. Although it's very clear business associations have fought very, very hard to not get civil liability in. And I think that's also what I understand, one of the major reasons why this law hasn't been passed yet, because some people are worried that you could potentially still apply it in one constellation or the other, which I think we can talk about later on. So thank you.
Thank you, Miriam. Can I just clarify one thing with you, or maybe one of the other speakers? The administrative fines that are imposed, are those going to the administration, or could they be redistributed to the affected communities? Is there any clarity on that?
It's not clarified, but the normal procedure is that it simply goes to the state.
Okay.
Robert, wouldn't you say so too? I think that's what my understanding of now is.
Robert,
I believe there is a provision in. I'm not sure if it's in the wording of the statute or in the government's deliberations, Begründung. But I believe that somewhere it said that part of the funds are being used for the development purposes. Part of the fines.
Okay, thank you. So we're going to conclude this panel. Sorry, I didn't want to start a Q&A, but I just wanted to clarify that point. So now I would like to really thank our panelists on the first panel. I feel like I know much better what the law provides now. So we're going to now turn to our second panel, and Tara will be chairing that panel.
Thanks, Anil. And at this point, we're going to stop the recording because we are going to go off the record now.